And now, it's The Law Show on CL 650. A comprehensive look at everything you need to know about the law.
Hey, and welcome to the show. I'm Zach Spencer, and thanks for joining us on The Law Show. Today we're focusing on estate law. This is something that will impact your life at some point, right? Everybody has to deal with an estate at some point in their life. And joining us is John White and Peter Lightbody from LakesWhyteLLP in North Vancouver. And I always love mentioning you have lots of parking, right?
Lots of free parking.
And where are you in North Vancouver?
We're on Marine Drive, just east of Capilano Mall, if you know Marine Drive, where Dave Buck Ford used to be, if you really know North Vancouver.
Yeah, and you only hire lawyers from North Van, right?
Well, that's right. We check your papers at the door.
And the reason I bring that up is because for the first time joining us here from Lakes White is Peter Lightbody. Now, Peter, you are an estate litigator, is that right?
So that's correct.
So what's the difference between the other people in your practice and what you do?
Well, John and I are both estate litigators.
Yeah.
And then there are a couple of lawyers, in particular John Lakes and Emmanuel Fung, who are what I would call estate solicitors, who are planning the estates, drafting wills, drafting other estate documents.
So the solicitors do the paperwork, the litigators, if you need to, go to court, right? That's the main difference?
That's right. So if an estate goes sideways for whatever reason, if a dispute arises in the context of an estate, that's the work that John and I do. It may or may not be something that results in a court filing, but of course most of it does. We try to head off disputes before they get there. But yeah, we're the ones who handle the dispute and handle the court proceedings.
So your background, you're from North Vancouver. You went to UBC and got your BA in English, and then you decided to go into law and be called to the bar. Why that?
Well, that's a good question. I sort of grew up with law. My father's been a lawyer in Vancouver he's now in the Okanagan, but practiced here for about 40 years and continued his practice in the Okanagan after he moved. So I learned about it at the dinner table. My father-in-law is a lawyer, so, you know, in the blood.
It's in the water, right?
Yeah. In the water.
Maybe
I had no choice.
And so what's your path to doing, you know, family law, estate law, not family law, estate law? So you've done a bunch of things. You worked in securities, fraud, and all kinds of things, right?
Yeah, well, I started out doing a lot of motor vehicle cases, which I still do. I worked a lot for ICBC. I still do the motor vehicle cases, but not working for ICBC. I was at a firm downtown that has a very busy estate practice, estate planning, and so from right out of law school, I was getting involved in estate disputes, which I found to be the most interesting part of my practice. So I've continued to develop expertise in the estate litigation.
Now, John, Lakes White is sort of a full-service law firm, right? You cover a lot of different things.
We cover a lot of ground.
Yeah,
that's right.
So you have somebody new here that can cover a lot of things, whether you're talking about ICBC, personal injury, or having to go to court for disputing a will, right?
Yeah, that's right. Right.
So you have all kinds of different services you provide.
Well, we do. I mean, we've got a strong litigation team doing all of the things that Peter talked about. Plus commercial litigation, real estate litigation, and most recently family law litigation.
Oh, so you're into family law, yeah.
As well as criminal defense. Darcy Lawrence of our firm covers off those two areas. Plus a large variety of what Peter called solicitor type work. Everything from real estate conveyances to matters involving small businesses and the organization of small businesses. So it's a pretty wide net that we cast with our six, soon-to-be 7 lawyers.
Yeah, and I guess the whole part of the real estate transaction plays in, obviously, when somebody passes and you have to get started on their will. So today we're going to talk about wills variation and WESA. So who's going to tackle what is WESA? W-E-S-A, what does that stand for?
Well, WESA is the Wills, Estates, and Succession Act, and it came into force at the end of March of 2014, and it replaced a number of previous statutes, including the Wills Variation Act, which is largely what we're going to be talking about today. And it was a sea change in the law of estates in British Columbia.
And is this different from other provinces?
It certainly is different from other provinces, and our wills variation provisions, when we get to those, are definitely different from every other province.
Because that's what I know. For as a layperson, I understand that our system is quite different from other places.
Well, it is, and maybe just zooming in on that a little bit. What we used to have a statute called the Wills Variation Act, which, as of March 31st of 2014, became a part of WESA, the Wills, Estates and Succession Act. But it's largely the same law.
So it just got rolled in?
More or less. With a couple of tweaks, it's the same law. So we still look at the same cases that were decided under the old Wills Variation Act when we look at wills variation. But what's key here is that BC's system is very different from most, if not all, of the other provinces. That is, it's possible to vary or to change the provisions of a will here in a way that it's not possible in most other jurisdictions.
Can you give me an example?
Well, the concept of varying a will is when the court is empowered on application to change what the will maker put in his or her will.
So I write a will and I say, this is what I want to happen, and then I pass, and then you can go to the court and change what my thoughts were. Right?
Some people can. I mean, I can't change your will, but for example, if you're married and you give all your property in your will to me rather than to your wife or to your wife or your children would have the standing to apply to the court and say to the court, look, giving all of Zach Spencer's assets to White is not just adequate or equitable. And we deserve to be heirs of Zach Spencer. And the court has the jurisdiction, which it exercises based on its discretion, to change what you put in your will so that those classes of people, spouses and children, are taken care of, at least to some degree, out of your estate.
And is that the main difference, is that the court can change? Depending on who brings forward an argument? Well,
I mean, there's a limited group of people who get to apply or have the standing to apply.
So as you said, it's that spouses and children.
Spouses and children is it. So not grandchildren, not friends, not charities, and not even people that we might think of as children, but who aren't natural children and who aren't adopted children.
So if I had, for example, foster child that I brought into my home and that child was 2 years old and raised them to an adult, and then you pass away and that child ends up being, say, 35 or 40 years old, and they've been in your life that whole time, they're not entitled to come forward because they never were made, say, you never adopted them.
If you didn't adopt them and the child is not your birth child, that person does not have standing under this act to apply to vary your will.
That child might have other remedies. That child may have contributed somehow to your estate and have some kind of unjust enrichment claim, or if you had made specific promises to that child, they may still have some kind of remedy through an estoppel type of claim, but they would not have a claim to vary your will.
So why was this brought in BC?
Well, back in the day, which would be around about 1920 or so. So this version of this legislation has been around in this province for 100 years, which in this province is a long time for almost anything.
Sure is, yeah. If the house is that old, they knock it down.
Well, yes, if not quite a bit younger than that.
Yeah.
But back then, the concern that the legislature had was that children or spouses who were not provided for in what was typically the husband's or the father's estate at that time would become impoverished because the wife generally didn't work. They'd become impoverished and they would become drains on the public purse. They'd become wards of the state.
So that was their way of getting these people off the government's payroll, I guess, and putting them back into the funds that they should have been entitled to.
Well, that's right. I mean, the legislature of the day made the judgment call, which I think we'd all agree with today was the right judgment call, to say that the once again, back then, the husband/father who had control of the assets couldn't essentially offload the people who he was expected to support onto the state, onto his fellow taxpayers, if you like, by making some improvident provision for his estate by giving it all away to, his, the SPCA or something,
or his girlfriend,
or his girlfriend,
or his illegitimate children,
or his girlfriend who works at the SPCA.
Yeah, well, that's even more
we
complicated.
see that.
So was there a precedent-setting case that sort of set this up, or was there something about the new WESA setup that made this happen?
Well, I mean, this is the original concept was a decision of the legislature, so it didn't really come to pass because of a judicial decision. The legislature put it into place, but there, as you can imagine, have been thousands of cases over the years that consider this legislation or its various successors over the years, up to and including the WESA we have today.
Mm-hmm.
Now, other provinces have dependence relief legislation, but it's
so they come around it a different way.
Typically quite different, and
Right.
it's typically needs-based. Whereas the wills variation provisions in WESA in British Columbia, need may be a part of the analysis, but it's not at the outset a needs-based analysis. And in fact, the way the legislation is drafted is to give the court very wide discretion. The provision in the legislation that allows the court to vary a will actually references whether it's in the court's opinion that the will does not make adequate provision for the proper maintenance and support of the spouse and children. So that anytime legislation introduces something like the court's
very
opinion,
broad, yeah.
it's wide open.
Yeah, and does that open up the? So are these just judges or judge and jury usually if you're going to court for WESA disputes?
These are judge alone cases.
Judge alone. So that you must get quite a difference depending on which judge you get.
Well, I mean, when one looks through the cases, one realizes that cases with similar facts can lead to different results. Sometimes it's just one little factor in a case which will change a result from one to the other. And that's something that we like to tell our clients as well, especially when we're being asked to go into court and to apply for what is essentially discretionary relief. That is, the court doesn't have to give it to you, but the court can give it to you. There's always a risk.
It's that gray area where they can say yes or no, right?
You are firmly in the gray area. And people who are contemplating bringing forward an application under those need to know that it's not a sure thing. Mm-hmm. There's no entitlement to have a will varied in your favor. It depends on the evidence and what the judge makes of the evidence.
And it's great for lawyers to get involved in these sorts of cases because you can bring advocacy skills to a fact pattern in a way that maybe you can't where the law is more cut and dried.
Yeah, you can, in the classic terms, argue someone's case for them, right?
Yeah.
And you can say this is why this person needs this. Right?
And so many different factors can come to bear on that individual case.
All right, well, we're going to take a quick break. We have lots going on today, and we're talking about estate law, John White and Peter Lightbody from LakesWhyteLLP in North Vancouver. When we come back, we're going to be talking about a whole bunch more about WESA, and when we continue on The Law Show on CL 650.
There's more of the show still ahead. This is The Law Show on CL 650.